Welcome to my channel, All for Health with Jane. Family, we are still on the Senzo Meyiwa murder trial. Today, on the 21st of May 2025, we are having Advocate Mnisi cross-examining Brigadier Gininda. Advocate Mnisi is still on the question, why did the NPA charge Mnisi? He wants to know from Brigadier Gininda what were the facts that led to the DPP charging Mnisi. What led to the facts that today they are here in this court because of this trial. The fact that these 5 accused were arrested. So Advocate Mnisi wants to know from Brigadier Gininda. Advocate Mnisi says he wants facts and not principles, as Brigadier Gininda puts it. Instead of giving him facts as he is asking, Brigadier Gininda gives him principles, gives him, the approach, the method they are using when they present their memorandum to the DPP, who is the Deputy Public Prosecutor. So Mnisi says, no, give me facts, tell me in detail what happened, what are the things that made you, that encouraged you, that motivated you to go to the DPP to present, and that led to this DPP charging Mnisi. This is what Advocate Mnisi is asking from Brigadier Gininda. Family, let's watch and listen.
My lord, I'm not talking affidavit here. I'm talking the factual basis upon which the state decided to arraign these accused persons to come and appear here. I don't know what was contained in that memorandum. All that I want to get from this witness, who is the lead investigator on this court, what is it that, what were the facts that he laid before the state on which he requested the state to make a decision on, which later on then the state indeed took a decision to arraign these people, this accused person, to come and appear here before court. There's nothing untoward.
Yes, sir.
Thank you. Before you start, Brigadier, I'm going to request you to take it point by point, because I'll also be taking notes here. I'll be very wary if I were to hear you saying something very, 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 very long, which I'll end up being confused and coming back to you. What is it that you are saying there? Just take it point by point up until then you say, no, yeah, I'm done. Do you understand, sir?
I do understand, my lord, but obviously the difficulty I may have, I'll try to summarize, because I don't have the memorandum with me, and that was done in 2020. But I do have a recollection of what it contains. So insofar as what it contains, I will go slowly so that Advocate Mnisi can write and take notes. But,
yes,
but it will be a summary of what I recall, and I'll refer to those points, my lord.
Family, in realizing that what Brigadier Gininda is giving is not evidence, not facts that Advocate Mnisi is asking for, but instead it's principles, it's methods, it's approaches they are using when they present their memorandum to the DPP. Advocate Mnisi stops him and insists that he needs evidence, he needs facts. He doesn't want methods that have been used. And he even says then the best thing is for the court to instruct Gininda to bring that memorandum before this court. Family, let's listen to Mnisi as he seemed to be pissed off by Brigadier Gininda's response.
I'm sorry, Brigadier, those are not facts. I'm going to request the court that if needs be, you go get your memorandum that you submitted to the DPP and then it be made available to us and then we work on it. Because now I don't know what evidence are you saying you had in respect of accused number 1. I don't know what evidence you're saying you had in respect of number 2. But then you're saying that is then the process that I also embarked upon. I want facts, which you presented to the state.
My Lord, issues such as the memorandum or the summary of the case by the investigating officer are filed in the B section of the docket and are privileged. They've got nothing to do with the information that is contained in the A section of the docket. We submit, therefore, my Lord, that the defense is not entitled to, not that there's anything to hide in the memorandum, just the issue of legal principle. They are not entitled to information or documents that are filed in the B section of the docket. But secondly, and more importantly, counsel says he wants facts. The facts have been presented before court by way of affidavits. We submit that it is therefore unfair to expect of this witness now to regurgitate facts that have already been presented before court.
As it please the court, my Lord, I think probably it eludes the state's attention or mind that I'm doing cross-examination on behalf of accused number 1. I am his new counsel. I don't know what facts were presented here on record, which is the reason why that witness is there, to assist me, to assist the court. But again, I emphasize, my Lord, there is nothing privileged where an investigating officer prepares a memorandum and says to the prosecutor, on the basis of this memorandum, can you please make a decision on whether you want to prosecute or you don't want to prosecute this accused person? What is privileged about that?
You know what? Have you read? Is it section 279 or 179? Which makes Batohi.
It's 179.
Batohi decide whether to pursue a prosecution or not.
Yes.
So this witness can help us because that evidence played itself in court here, which evidence was read to, it was Johnson. Who was the guy then? The guy they used to call Sean the Sheepman. What's his name?
Sean Abrams.
Is that the one who decided?
No, it is the current NDPP.
Oh, Batohi.
Yes.
Yeah, fine. So Batohi goes over that evidence, and the decision is his, not this gentleman.
No, my Lord, maybe
just listen to me. And it's a misnomer to say the state doesn't have privileged information. What this witness discusses with Batohi is privileged. The same thing as what you discuss with your witness is privileged. And that is the law.
My Lord, I am saying the basis, the facts that he submits to the DPP or to the NPA and requests them to make a decision on, we are entitled to know that. And that is exactly what I'm requesting this week. And my Lord, let us for a moment assume that that is privileged. He said he submitted, he made a presentation to the NPA and requested NPA to make a decision on. He did this, in this instance, he did that in the form of a memorandum. I'm simply requesting him to tell me the facts that he presented to the NPA, which facts have got to do with these accused persons that are before court here. They are entitled to know what is it that Gininda told the NPA about us, which ultimately the NPA then decided that we should be arraigned for trial here.
Okay, let's hear you. I mean, I don't want to waste time. Let's hear Gininda.
Maybe just one aspect, if I may be so presumptuous as just to mention that, to respond to one aspect. counsel says he wants to know the facts on which the decision to charge the accused was based. That decision was based on facts contained in the dockets. And he has been furnished with copies of the statements, copies of the docket on which the information to charge the accused was premised. Nothing more, nothing less, my lord. He already sits with the information. I cannot fathom why he would want a summary that an investigating officer makes for himself and for the purpose of briefing the DPP that he should have a decision to charge the accused was based.
Yeah, okay.
As it pleases the court, my lord. It is so that we have a docket, but there is nothing wrong in me while serving that docket to request this witness to give that factual basis or to give the facts on which he approached the NPA. This is cross-examination. The state cannot simply assume.
You know what, I'm going to overrule you. I just read 179. Just read what 179.
Then I'm not going to proceed.
Just read 179.
Well, the heading says prosecuting authority, section 179, subsection 1.
Yes.
There is a single national prosecuting authority in the Republic, structured in terms of an act of parliament and consisting of a national director of public prosecutions who is the head of the prosecuting authority and is appointed by the president as head of the national executive, and B, directors of public prosecutions and prosecutors as determined by an act of parliament, subsection 2. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. I think that's what the court has just referred to. Subsection 3, national legislation must ensure that the Director of Public Prosecutions, subsection A, are appropriately qualified, B, are responsible for prosecutions in specific jurisdictions, subject to subsection 5. Then subsection 4, national legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. Subsection 5, the National Director of Public Prosecutions, A, must determine with the concurrence of the cabinet member responsible for the administration of justice and after consulting the directors of public prosecutions, prosecution policy which must be observed in the prosecution process. B, must issue policy directives which must be observed in the prosecution process. C, may intervene in the prosecution process when policy directives are not complied with. And D, must review a decision to prosecute or not to prosecute after consulting the relevant director of public prosecutions and after taking representations within a period specified in the National Director of Public Prosecutions from the following: Roman figure 1, the accused person; Roman figure 2, the complainant; Roman must exercise final responsibility over the prosecuting authority; and lastly, subsection 7, all other matters concerning the prosecuting authority must be determined by national legislation. That is the sum total of section 179.
Yeah, you can answer that if you think you can. But what the law says, there has got to be litis constantatio before a person can be charged in a court of law. In other words, the accused himself must plead. And when he pleads not guilty, then that is the commencement of the case. And if the accused or his counselors believe that these charges are frivolous or they are brought for a malevolent reason, then it brings an application to court for the judge to decide whether in fact there is evidence, prima facie evidence upon which a person may be charged. So even Batohi doesn't just read. He inspects the docket, he goes to the law because this is what guides him. And only after that does he charge a person. And the law specifically says a director of prosecutions may not charge a person if there is no sufficient compelling reason. Okay, you can answer Mr. Mnisi, if you are able to. That's what the law says.
May I just assist the court, my lord?
No, you don't assist me, please. I've told you what the law is. Don't assist me.
No, I'm not.
If I'm wrong, take me on appeal, take me on review, fine. But I'm saying this witness, you can cross-examine him on that very aspect.
Thank you, my lord. Thank you.
Family, even after acts and sections have been read to Advocate Mnisi, even after Advocate Baloyi has advised that what Advocate Mnisi needs is in the docket, the information that forms the basis of this case is in the docket, Advocate Mnisi insisted that he wanted Brigadier Gininda to give those bases himself, to give that evidence that led him to go to the DPP and the NPA and presented that to them for the DPP to lay charges against Mnisi. Family, thank you so much for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.